Sahaj Vidhi www.sahajvidhi.in Question 1. Critically examine the provisions relating to few major offences which fall under the Offences Against Marriage in the Criminal Law of India. Support your answer with case law. Model answer. The Indian Penal Code, IPC, 1860, historically contained several provisions under Chapter 20 of offences relating to marriage, aimed at protecting the sanctity of marriage and addressing wrongs committed within or the marital institution. A critical examination reveals both their historical significance and their evolution, particularly in light of constitutional principles. Major offences against marriage. 1. Bigamy, Section 494 IPC, provision. This section penalizes marrying again during the lifetime of a husband or wife, where the first marriage is subsisting and valid. The second marriage must also be solemnized according to the personal law of the parties. The punishment is imprisonment up to 7 years and a fine. Critical examination. Bigamy aims to uphold the monogamous nature of marriage, which is a cornerstone of many personal laws in India. It prevents exploitation and protects the rights of the first spouse. However, proving the solemnization of the second marriage can be challenging, as often such marriages are conducted secretly. The exception for a spouse continuously absent for 7 years and not heard of reflects a practical approach to situations where a spouse might be presumed dead. The Supreme Court in Sarla Mudgal v. Union of India, 1995, highlighted the issue of individuals converting to another religion, e.g., Islam, which permits polygamy, solely to contract a second marriage without dissolving the first, holding that such a second marriage would still be bigamous under Section 494 IPC if the first marriage was solemnized under Hindu law. 2. Adultery, Section 497 IPC struck down provision. Prior to 2018, this section criminalized sexual intercourse by a man with the wife of another man, without the consent or connivance of that man, provided such intercourse did not amount to rape. The wife was not punishable as an abettor. The punishment was imprisonment up to 5 years or fine or both. Critical examination. Section 497 was a highly controversial provision. It was criticized for being discriminatory and archaic. The Supreme Court, in Joseph Shine v. Union of India, 2018, unanimously struck down Section 497 as unconstitutional. The court held that the provision violated Articles 14, equality before law, 15, non-discrimination on grounds of sex, and 21, right to life and personal liberty, of the Constitution. It treated women as property of their husbands, denying their agency and autonomy. The court observed that adultery, while it could be a ground for divorce, should not be a criminal offense, as it intruded into the private domain of individuals and perpetuated gender stereotypes. This judgment marked a significant step towards gender against equality in Indian criminal law. 3. Enticing or taking away or detaining with criminal intent a married woman. Section 498 IPC provision. This section penalizes anyone who takes or entices away any married woman, or conceals or detains her, with the intent that she may have illicit intercourse with any person. The punishment is imprisonment up to 2 years or fine or both. Critical examination. Similar to Section 497, this provision has been criticized for treating a married woman as the property of her husband, whose possession is being interfered with. While it aims to protect the marital institution, its language and underlying philosophy are seen as patriarchal. In the post-Joseph Shine era, the continued relevance and interpretation of Section 498 need careful consideration, especially regarding the intent that she may have illicit intercourse, which implicitly links back to the concept of adultery. However, it remains on the statute book and can be invoked in cases where a woman is enticed away against her will or without her informed consent, particularly if there's an element of coercion or deception. 4. Cruelty by husband or relatives of husband. Section 498A IPC provision, introduced in 1983, this section penalizes a husband or his relatives who subject a woman to cruelty. Cruelty includes any willful conduct likely to drive the woman to commit suicide or cause grave injury or danger to life, limb/health, mental or physical, or harassment with a view to coercing her or any person related to her to meet any unlawful demand for property or valuable security. Critical examination. Section 498A was enacted to combat the rising menace of dowry deaths and domestic violence. It is a powerful provision, making cruelty a cognizable, non-bailable, and non-compoundable offense. It has provided significant relief to countless women suffering domestic abuse. However, it has also faced criticism for alleged misuse, leading to false complaints and harassment of husbands and their families. The Supreme Court, in Arnesh Kumar v. State of Bihar, 2014, issued guidelines to prevent arbitrary arrests under Section 498A, emphasizing the need for police to conduct a preliminary inquiry before making arrests and for magistrates to be cautious in remanding accused persons. Despite concerns about misuse, Section 498A remains a crucial legal tool for protecting married women from domestic violence. In conclusion, while some provisions like Section 494 continue to serve their purpose in protecting marital sanctity, others like Section 497 have been rightly struck down for being unconstitutional and discriminatory. Section 4984, despite its challenges, remains a vital safeguard against domestic cruelty, reflecting the evolving understanding of marriage and women's rights in India. Please visit our website www.sahajvidhi.in for more content.